Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Here we bridge the gap between technology and the law, bringing you the forefront of electronic discovery. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery. With over 20 years at the junction of law and technology, I'm excited to help bring together leading experts and practitioners who provide a wealth of knowledge on electronically stored information.
And my name is Brandon Mack. I'm the co-host of our podcast. And with 2 decades of eDiscovery experience myself, I'm also thrilled to be able to participate in bringing you information and education around the world of eDiscovery.
NeLI is not just about discussions. It's about education and it's about collaboration.
Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note that while we engage with some of the brightest minds in the field, the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. And welcome back to another NeLI Pod podcast, the official podcast of the National eDiscovery Leadership Institute. And today we have the privilege of speaking with a very distinguished guest, Magistrate Judge Allison Goddard of the U.S. District Court for the Southern District of California. Judge Goddard brings with her a wealth of experience to the bench with a career spanning private practice, both on the plaintiff side as well as the defense side. And now serving as a federal magistrate judge. Throughout her tenure, she has seen firsthand really the evolution of discovery itself, the challenges of managing electronically stored information, or ESI, and the impact that legal technology has had on what I'll call modern litigation. So in today's conversation, we are going to dive pretty deep into some key issues facing the legal profession, including best practices for eDiscovery, importance of proportionality in the face of all this new legal technology, all these new different data types and forms that we see, the role, most importantly, of AI in litigation. So Judge Goddard could not be a better, more suitable guest here to talk about that with her most recent publication, the Sedona Conference. And what I really want to know is, what is going to be the role of the bench when it comes to all of this new AI? Brandon and I have a ton of wonderful questions, but before we get started, Judge Goddard, thank you so much for joining us today. It is really a pleasure to have you here.
Oh, thank you so much. It's an honor to be here. NeLI is one of the best eDiscovery conferences that I've been part of for several years now. So I love the idea of continuing the learning that happens in that short period of time and stretching it out across the year. So thanks for having me be part of this.
Well, I love that you said that, by the way. So thank you very much. So this is really kind of breaking news, I want to say. So let's get right into it. Let's talk about the Sedona Conference and AI guidance. So the Sedona Conference has always been this leader, I'll say, in eDiscovery best practices and the guidance that it puts out and the publications that it has. And most recently, you teamed up with some others. I want you to talk about, please, who it is that you teamed up with and talk about this recent focus on AI for the judiciary and how do you hope that this guidance is going to shape the way that courts and I'll also say litigants approach AI-powered discovery.
So let me give you the backstory. I'm going to say it like that, but it's probably not going to be as interesting as that sounds. But let me give you the backstory. The guidelines were the product of an ABA AI working group. And then the Sedona Conference had the leadership of being the first to publish them. So the working group was headed by Judge Scott Schlegel, who's from Louisiana, who sits on the Louisiana Court of Appeal, and then Judge Herbert Dixon, who's a senior judge at the D.C. Superior Court, and Judge Xavier Rodriguez, a district judge from the Western District of Texas, and then Judge Sam Thuma, who's on the Arizona Court of Appeal. And then we joke, it's 5 judges walk into a bar and we run into a lawyer, computer science professional, and that's the one keeping us all honest, and that's Dr. Maura Grossman, who's a computer science professor and also a lawyer.
And also a guest of the NeLI Pod podcast as well.
And actually, I met her through NeLI. That's how I met Dr. Grossman, and she's become like a very important collaborator for us and helps us get judges trained on Gen AI and eDiscovery issues. So I'm very grateful for that connection that came initially through NeLI. But this group, I got to know Judge Schlegel through, we have kind of like an informal like email chat group of a group of judges from around the country. And it's not too big. It's about maybe 7 or 8 of us. And as the AI news started to come out, we just kept sharing information with each other. And that's how I got to know Judge Schlegel. And then when we were all kind of, he's the one who said it first, but everyone was like, I've been thinking the same thing. It's that we really need some sort of a guidance for judges on how to use Gen AI. The ABA had come out with their statement for how lawyers should be using it, or things that like guidelines for lawyers. We thought we need to do this for judges. And we wanted to do 2 things. One is kind of set up some guardrails that we candidly, like the judicial systems haven't put in place quite yet. Some have, some haven't, but we don't have any firm federal rules about how judges should be using AI or Gen AI in chambers. And the same goes for a lot of state courts too. So we thought, as a peer group, we should step out in front of this, because not only do we want to say these are some important guardrails if you're going to use it, but the second is we wanted people to start using it. So we wanted the message to get across that you can use it responsibly in your work as a judge. And it's not like using Gen AI from a legal in a legal practice or in any way in the legal profession. It's not an all or nothing. It's not like a switch where if a judge uses it, they use it to make decisions for them, and that's the only it. There's so many in-between ways you can use it to make your work more efficient and I think better. And so we wanted to bring that. That was the genesis of this, and that's how we got to the guidelines that the Sedona Conference ultimately published.
If you could take the guidelines or the guidance and distill them into a few points for practitioners to know, for them to communicate to their clients, what would those few points be? Really thinking about it here are the things that we can already tell you should do, or that you shouldn't do, or that you should figure out and plan ways to let us know that you've done. What would be those few practice points that you would take from it?
Well, so one is that it's a practice point, but it's also important for people to hear that judges are cognizant of that. And it's the principle of human in the loop, judge in the loop, JITL instead of HITL. I don't know. We got to come up with some kind of fun acronym for that. But as I use more and more tools in my own work, I could see how there's a risk of becoming complacent, because they get better. A lot of the tools we do use are kind of RAG-based tools, so they're trained on actual bodies of legitimate legal authorities. And so that constant reminder of human in the loop, which serves as one, a best practice guideline for judges, but 2, I would think lawyers are happy to hear we're focused on that, because you don't want, it builds confidence in how we're using these tools within the system. And then the second takeaway is just that they should be using it. Like, I do a lot of training for judges, and now I've done it kind of around the country, and I just show them some of the ways that I can use Gen AI in my own work. And it's really fun, because you can hear the jaw drop over really simple things. You would laugh to know that, like, if I ask Claude, and I'm just using that as a sample, not advocating any particular tool, but if I show like how I might ask Claude to help me with in writing, be like a writing partner, they're like, that was so fast. I can't. And when you see someone do it, and you see it in a way that's like literally can help you do your job, you're much more likely to try that out yourself. So when we first started, it was like, you can use ChatGPT to draft a packing list if you're going to Madrid next summer or something like that, which is, it's a little bit, sure. Yes, that's kind of cool and nifty, but can that really help me do my job? Well, how about I can upload a special verdict form for a trial that the parties have submitted, or even that they're disagreeing with, and I can feed both of those into an AI tool, and I can ask it to give me 3 options that make that verdict form more understandable for the jury. And then I've got 3 different options to look at that I can play with. And then if I like it but I need a little bit different, I could just ask the AI tool to run another draft. Like, hey, that's good, but I still think it's a little confusing. Or, you took out the word negligence, and that's actually a really important word in that verdict form. So you need to put that back in. And I think people are surprised to see the iterative process that you can engage in. But once they see it, I think they're much more likely to try it themselves or talk to their clerks about trying it. And in the federal system, that's a big issue for judges because our clerks rotate every year. The traditional model in federal courts is that you have, 2 to 3 clerks, depending on what type of judge you are, and your clerks rotate in and out every year. Some do a 2-year term, some of us have some career clerks, but for the most part, they cycle. So when I'm trying to advocate to the federal system, like we need to get these tools in, we need to enhance our research contract with this provider to include their AI tools, I say, because guess what? Our next, come September, the next wave of clerks is going to be using a different set of tools or used to using a different set of tools than we use. So we need to make sure that you don't have judges trying to teach them how to do Boolean research. So that's what I really, if anything, if it can do anything, I would really like for judges to read these guidelines and say, okay, I can do this. First of all, there are safe and responsible ways to use it. I have to always have a human in the loop, and it's worth playing around.
I like that as guidance. And I want to go back to something that you said, because you said something really interesting. You used the word complacency before, right? You can get very complacent using the tools. It's almost like, and I'm going to loop judges into this fold here when I say most lawyers, as well as judges, fall into one of two camps here. It's I'm going to heavily rely upon Gen AI to the point where it looks real enough. I'm just going to copy and paste it, and I'm in a rush. I'm going to put it in, and I'm going to submit it to the court, or I'm going to submit it back to the attorneys. And there's the other side, which is like, I don't really understand what's going on, what kind of data it's being trained on. And I'm really afraid to put anything into it whatsoever. And it's all very black boxy. I don't want to use it. Somehow there's got to be this middle ground. And I like what you said at the very end, which is there's always got to be human in the loop, right? We'll come up with a good acronym maybe by the end of the show. But there are those two camps. It's I'm going to use it and just, hope for the best here because this looks real enough. And I can't even imagine typing anything into it because someone's going to steal my data and et cetera. How does the bench come to grips with those very dichotomous look at where we are with Gen AI?
Well, we're in the middle of coming to the grips of it now, I think, because what you see is you've got these standing orders for a lot of courts, and they're really hesitant about lawyers using Gen AI, hallucinations showing up in the briefs that they submit. And I think there's also this concern that if I type something into ChatGPT or Claude or a different type of program, and I'll default to Claude because it's one I use the most, but that's not an endorsement. It's once you know something, it tends to be what you use. Plus, it tells me good morning whenever I open it up, so I like that. It's very friendly with me. We all need affirmation, right?
I do agree with you, Judge. I do agree.
Yeah, but so I'll just use that as an example, right? I know I hear from judges all the time, and they say, "Well, what if I type in?" Well, I'll give you an example how I used it today. I had a settlement conference. I was frustrated because the parties weren't prepared, so I'm going to issue an order to show cause. Why I shouldn't take certain actions unless they kind of clean up what they're doing. So I put in Claude, I just typed in a bunch of things about what happened in this settlement conference. And it wasn't organized, it wasn't focused. And I typed out, it said draft an order to show cause. And it did it really well. It was a pretty clean document. It wasn't perfect, but it was clean. And it was a good starting point for my clerk she's going to do her run of it, then I'll go back and look at it again. But it definitely was faster than if I tried to start from the beginning. And a lot of judges are really hesitant. I think what I would hear from some judges would be, but oh my gosh, what if someone else is in Claude later that day and says, what does Judge Goddard want Claude to do? Or that they could somehow go and get my prompts. But before I started to use Claude, I went and read the terms of service. And the terms of service say that Claude won't use my inputs or outputs to train the models. So theoretically, that shouldn't be happening. And I think that it's reasonable for me to rely on what the terms of service say. I'm not saying that companies have never breached those terms or done things they shouldn't have done with their customers' privacy, but I think that's reasonable. I also think you don't know that much about my judicial thinking, except maybe you might read what I put into Claude. I gave you a quick summary, but if you read what I actually put into Claude, you might be like, wow, she was really mad. Right? That would be all you really learned about that. That's new, right? That's not some special judicial secret sauce. And when I talk to the judges about that, I say, well, you signed warrants and you get people's Google search history. Does that stop you from putting things in that search bar? Because you can learn a lot from a person by looking at what they're searching on Google. And that's not publicly available, just like your prompts in ChatGPT or Claude or et cetera, Gemini would be. But it is, I mean, I guess theoretically it exists somewhere in the ether and could be, but I just don't know that it really tells you that much. So I do get some pushback from judges about concerns about that. And I don't think that's an illegitimate concern. It's right for them to be concerned. That's a really smart and good question to ask, like, okay, how's my information being used and how could it come back to bite me? But I think there's answers to that where you still should be comfortable putting that prompt in.
Judge Goddard, I'm listening to the way you're talking about how you use Claude and other AI tools, especially with drafting and things like that. And I remember, it reminds me of an AI professional who in the legal industry who told me the way you should treat these tools is treat them like a really, really knowledgeable first-year associate who has zero experience. And so you're going to double check everything they do. You're going to be very, very precise in how you're giving them instructions. But no, they know what you're asking them, but they don't really know what they're doing and how they respond. I mean, would you say that's an accurate way in which your experience in using these tools, does that bear that out for you?
Yeah, I've used that same analogy. And so many times, but except for I take it a little bit further. It's not just a really bright and smart first-year associate. It's one who always wants to make you happy and always wants to please you. And so even when they don't necessarily know the answer, they might make up one because they don't want you to be disappointed that they didn't know the answer. So that's a great analogy, but I always think of it as like it's the most eager first-year associate, right? I also think when you're like, we all get fatigued in our work. And if you're working on something and, we don't have a lot of stuff on settlement, which is a lot of what I do. I don't have a lot of time to think about things. It's really rare that I have in my calendar, because I do so many settlement conferences, 3 hours in a row to like work on a document, right? And I kind of religiously guard that time, and my clerks will book out time for me in those big chunks because that is uninterrupted time, right? But that doesn't mean that I don't have a lot of stuff to do, even though I only have a short amount of time to do it. So if I'm writing like a quick order in a criminal matter, right? It's a really good and helpful thing to go and run a paragraph through an AI tool to make sure it makes sense. Or if I'm stuck from looking for an analogy, I'll just pop in there and I'll say, I have a lawyer who is just, everything is so dramatic and it's, but I don't want to say making mountains out of molehills because it seems kind of trite, right? I'll say, can you give me, some other analogies I could use for that? And I'll look to see if I can find that. And I think that helps. I mean, I like to think it makes for better writing. You could, I suppose, have just like a order that's just full of bromides because you just get them all from AI, but like, hopefully we're better writers than that. And you try and find a way to kind of shuffle it in. But also if you're tired and you've got to explain, like you could upload a brief and like where you have to summarize the party's position in an order. And there's some orders that I do all on my own. I don't use a clerk at all because I don't really need to research them, because it's like maybe it's on the criminal side, it's a bond order and it's something I decide all the time. And I know the law and the law hasn't changed. But I do need to write an order that shows the parties that I've read their briefs, I've considered their arguments, and this is the reason why I'm either agreeing with them or not agreeing with them. That process alone builds public confidence in the judiciary, right? feeling heard and seeing tangible evidence that that you were heard. And so the way we do that sometimes can be challenging. Sometimes you just run out of words, right? But I can upload the briefs into a tool and say, can you summarize plaintiff's argument? And then I've read their brief. I've read the summary. I tweak it to make sure it sounds right. And then but that's a much faster way for me to draft that order than to try and think of a different way to say what they said. Because I don't want to just quote, I don't want to block quote them. I want to have an order that's interesting to read. So in that sense, it goes a little bit beyond just the first year, although the hallucinations I think I attribute to the very eager first year associate. It really is kind of like a writing or a thought partner.
There is so much that I'd love to unpack with everything you just said, Judge Goddard. One of them, you brought back memories of when you're talking about creating this language in order to show cause, and that you throw your thoughts in, you ask it to come up with it, and it comes up with a pretty good first draft. And all I could think to myself is the days when we used to have to go to the library to pull out a book in order to find the template, and then manually actually type into Word what you're doing. And what I'm hearing you say, I think, is that you have a lot of really important decisions to make throughout the day, and leveraging generative AI is helping you focus in on the thinking and the really important stuff, and not walking down to the law library or going onto an online research database to find the right template for an order to show cause, because you're able to type in your thoughts and boom, it pops it out. And so part one of my question for you, because I don't want to ask you a compound question, Judge. So part one of my question is that it seems as if what you're saying is that it frees up time to do the monotonous work so that you focus in on what really matters, which is counsel knows that you have heard them. Is that right?
Yeah, I think that's true, and I think it's fair. But it also helps me demonstrate to them in a faster and more efficient way that I have heard them, that I read their brief, that I understand their argument. It's funny because I always joke. I started out at Cooley when I was first an associate, and I always joke that I had ChatGPT in 2000 when I started, and people always like, "What?" I said, well, it was called Seth Rafkin. If you're ever listening to this, I hope you enjoy this. He's a lawyer who was a few years ahead of me, and he was, in my mind, he was the smartest associate at Cooley. And if I was going to be successful, I needed to be more like Seth. And so we have the document, what do they call it? Docs open. Anyone remembering this? You getting twitchy when we talk about it. With docs open. And so when I had to draft anything, a motion to compel, a motion for summary judgment, the first thing I did was I went into docs open and I looked for anything Seth had written that looked like that in a case that was similar. And I modeled everything I did after him. And so I don't see it as really that different from that. It's just turbocharged, and I'm getting inputs or suggestions from more than just Seth.
I like that. I'm going to try to figure out a way to weave that into my conversations as well. So one other thing that you said I thought was interesting as well was this idea of just inputting the plaintiff's arguments, inputting the defense arguments, what have you, and then being able to have it summarized. So again, you could focus it on the work. Now, I clerked for a judge when I came out of law school as well, and I typically put all that stuff together for the judge. Whether I did a good job or not is something that she might have to talk about on another program maybe. But I'm curious, is it replacing the law clerks in some sense? The way you had phrased it is that you do some of these on your own, but is it a replacement for a law clerk, or there's now a more efficient or a more meatier place for the law clerk now?
Yeah, I definitely don't think it replaces the law clerk, because I think, like, when I draft an order, and not all judges do that, right? Not all judges like will start an order or draft an order from start to finish on their own without their clerks. And so it might be a little bit of an anomaly. I don't do it all the time. I don't have time to do that all the time. I need my clerks to be doing a lot of this work. But the clerks can use it that way too. And I have guidelines for how AI can be used in my chambers, and my clerks are allowed to use Gen AI tools. They just have to let me know and we have to talk about it to make sure I'm comfortable with the tools they're using. But I want them to use that too, because they have families. I don't want them here, 80 hours a week. I want them to do their job with integrity, but also with efficiency. And so I want them to have all the tools that they're like, I wouldn't make them handwrite their briefs once we had Microsoft Word, right? I mean, I want them to be able to use all the tools that are available to them to get their job done in an efficient way without compromising the integrity of it, which I don't think is required at all.
Judge, I almost feel like I'm stepping back in time 10 years and asking this question. Of course, 10 years back, it was a question about a completely different technology, but it was the same question, and that is the black box question. Are you at all concerned about the fact that whatever's going on behind the curtain with Gen AI, we don't really know what it's doing? You've talked a little bit about privacy concerns and is your data being used? And even if we set that aside, we don't necessarily know as the average practitioner what a generative AI tool is doing with data, how it's figuring out what answers to bring us. Does that give you any concern? Is there any way that you think that the judiciary or the bar should be dealing with validating what they're getting back from these tools to be able to say, yeah, bias, the black box nature of the tool, it just isn't a concern?
Yeah. So that's a great question. And there's two different ways to look at it. There's one as a user. Do I care? Do I need to know? I mean, I understand. I've sat through plenty of CLEs about what an LLM is, and I have some basics down about that these are in some ways it's just like a text predictor. The way so, and I probably, because I've sat through so many different CLEs on that or programs on that, I may know more than your average judge about it. But I don't feel like I need to know any of that to use it in the way I'm using it, like to use it to be kind of like an idea generator, to use it as like a thought partner for writing, things like that. It would be different though, like what we're about to see is, and it's just coming to the front. I haven't had a case where I've had to deal with this now, but there's huge issues coming down the pike for judges on how other people are using it and how that presents in the cases we decide. So for example, discovery. How is a Gen AI tool being used in eDiscovery? Is it producing a fair result? Is it producing, a complete result? Is it getting us to the reasonably responsive set of documents that this party should be producing in the case, right? We're not going to ever be able to open up the hood and look under it, or much less understand it once the hood's popped. But we're going to do that evaluation the same way we did with TAR, right? The same way we did with your basic search terms. Parties are going to have to submit expert declarations to educate the judge on what the judge needs to know. And I don't think it's going to be a matter of we don't have to become computer scientists. We never have. We won't. We can't. Sorry, Maura Grossman is a unicorn. Like most judges just can't be so proficient in so many very different areas of the brain. We're issue spotters, and our strength is in our ability to fly above the forest at 10,000 feet and look down and identify where the problem areas are. And so we're going to follow that model of you're going to need to be able to show through expert testimony whether or not you're going to need to either defend your work if you're the producing party or challenge what was done if you're the receiving party. And case law will develop. Hopefully, I would like to see that case law develop using Gen AI and discovery. If the tools become more economical for smaller model cases, for smaller cases or smaller amounts of data, then you'll see lots of case law. But even with TAR, I don't think we have a ton of case law on it because I think it's really expensive. And so it makes sense in a smaller number of cases, even though I think it would be very good technology if we could find a way to scale it down for the smaller cases. But so that's a long way of saying, like, you're right. We don't know what's in the black box. we're going to have to figure that out. The other thing, that's Gen AI and discovery, but Gen AI and how companies are making decisions. Yes, the companies who are using a Gen AI tool to make decisions that could draw the attention of a class action lawyer or federal agency as far as discrimination is concerned, they need to be ready to defend that. There needs to be some way to test the AI tool, even if you can't look inside and explain exactly how it's doing it or why it's making a decision that you've tested, you've bumped it up against several examples. The easiest one I think for people to understand is resumes. If you have the same resume, but you change the name on the top to something that is more ethnic, that has the more ethnic sound to it, is it going to yield the same or different results? And the ways to test that system. So it just depends on how the AI is being used functionally to how deep you have to go into the black box. But expert testimony is going to be really critical in all this.
So now you've gone somewhere which I think is, to me, because I'm a bit of a geek, I think this is kind of exciting. Okay. So it's kind of exciting, but also,
I'm sorry about that.
Yeah, I know, me too. I know.
No, it's from one nerd to another.
That's right.
It's good.
So when I listen to what you're saying, though, I start thinking about all these other things that we need to know about generative AI, and specifically in the context of generative AI in eDiscovery tools. So if I am an attorney who's utilizing generative AI inside of an eDiscovery tool, and I am putting together some prompt, and if I type that prompt in a certain way, it potentially could have bias in the way that I have asked the question in order to get back an answer. And so it gives me back documents that I think are responsive in nature because of the way that I asked the question. So now the question becomes, well, at a Rule 26 conference, is there going to be an argument around both in the ESI protocol, as well as an argument around the use or not utilization of generative AI to such a point where it becomes degenerative, I guess, if you will. And as opposed to becoming adaptive, and now it's maladaptive, it's become something that is a negative and not a positive, because now we're spending a lot of your time in your chambers and a lot of clients' money arguing about what was your prompt? Show me your prompt. I mean, is that where we're going with this? Just a very expensive route, just very similar to TAR in some nature from a decade ago. But now we just keep arguing about, well, I'm utilizing, the application and so be it. But is it? Or we're just going to keep saying, show me your prompt. And we're going to argue this, and it's going to cost a whole lot of money, and we're never going to get to the substance.
Yeah. Well, let me talk about two different ways that I think we're going to see it. And I'll talk about the easy one to solve. And I think that, every document production has the producing party and the receiving party. And I think that as the sophisticated litigants may have issues with how the receiving party uses Gen AI to review those documents, which I think is going to be kind of interesting. And they may want to put some restrictions on what types of Gen AI tools the receiving party is using, particularly if the information in that data set has been designated as confidential in any way, shape, or form. So I think there's easy ways to get around that. But I do think that judges are going to have to be educated by the parties on why or why not whatever particular tool the receiving party wants to use to review those documents is going to use to do that, and whether or not it presents a risk from a security perspective. One of the things I don't see in protective orders, which just always surprises me, I hardly ever see it, is any sort of restrictions on how the receiving party is keeping the information. How are they? Is it in Dropbox? Is that okay? Are you okay with them using Dropbox? Is it being stored on a local server? I don't know. The parties go to all these links to designate all their information as confidential. And then it seems like a lot of, I don't want to cause more, this is probably going to be a nightmare. People are probably going to start putting this in protective orders. We'll be fighting over it. So I may have just hurt myself. But anyway, it's an important question, I think, in how that information is governed. They're going to put that information, you're going to hand over that information that you've taken all the pains to designate confidential, but you don't have any say over how it's being held or even know or understand. That's one thing. But let's talk about, to me, that's a little bit easier as far as how you use Gen AI tools, because the reality is a judge is going to say you can use that tool as long as it's not going to, as long as you can show it's going to have basic security standards, right? Okay. Now on the other side, the producing party is a much thornier issue. It hasn't come up before me, but I'm pretty sure it will. So I have to be careful about not prejudging it. But I can tell you, if you put that debate, if you wash it through our normal system, our process, I have Rule 26 guidelines. I'm really careful. They're not just for ESI-driven cases. They're for all cases. And then you have to talk about ESI, because I don't want, what happens in a lot of these cases is every case involves eDiscovery now. Every case has ESI. But lawyers in like single plaintiff employment cases say, oh, well, I don't have anything like that. I don't need to worry about it. But sure you do. And if you, my Rule 26 guidelines require you to go through those steps of talking about ESI, even if you may not have thought about it as an ESI case. But once you get to that step, I require you to meet and confer. If it's search terms, if it's prompts, I want you to meet and confer. Now, I do recognize, I can absolutely see a case where, let's say, a defendant in a class action says, no, I'm not going to share my prompts with you. What I will show you is that we've done this collection, and I can give you some samples or some either data or some sort of statistics to try and bolster the fact that whatever your prompts were that you put into the black box, they can be trusted because they're yielding results, right? There's going to have to, so if you don't want to share your prompts at all, you're going to have to be ready to at least provide some information that gives the other side and the court some level of confidence. In the perfect world for me, although I don't know as much about this as the lawyers do, I've tested out 2 different Gen AI discovery tools through the demo process, where you spend a few hours with it and you go through a sample data set. It was very interesting, very helpful. I may be one of like 3 judges in the whole country who is a nerd enough to do that, if you want to talk about geeking out, right? But I'm very hands-on, and I just wanted to see it. So they're not going to have that experience. You're going to have to explain to them what that looks like. Through that experience, I know, like, search terms and prompts are very different things. But if you don't want to share your prompts, you better be able to explain that to the court. And you probably should get an expert declaration on that, because lawyers will tell us anything.
Is there an obligation, though, to even demand prompts? I mean, there's an obligation. I mean, we argue over keyword search terms all the time. And and we argue over whether TAR should be utilized. And there are some times where the attorneys are just like, no, not at all. I'm not going to. But I would have to imagine that starting to ask the question about, and again, I don't want to bias, and if you haven't ruled on this, I certainly don't want to get into you put you into a position where you have to pre-decide, as you said. But it does beg the question as to whether or not there is going just to be this incessant arguing about, did you use Gen AI? If so, tell me. What was the application? Do we have to depose who crafted the LLM for this eDiscovery application to understand whether there's any inherent bias, et cetera? Or am I just doomsdaying this in advance?
Yeah. So you have to talk about all of that under my guidelines. And if you don't want to talk about it, let's say if you said, well, I don't think my position is I shouldn't have to tell you how I'm doing this. I should just produce documents to you, and you should be relying on my signature under Rule 26G to the responses that I've done a reasonable search, and that's it. And there may be space for that. But one of the ways I would probably respond to that is, okay, well, if it turns out that you were wrong, and your client has spent all this money on this huge process to produce these documents, and then they are able to make a case down the road, either through a deposition of one of the executives at the company or through the marketing person, and they say, oh, well, no, we had these meetings and we talked about this all the times at these meetings. And then the plaintiff comes back and says, oh, we didn't get any of those, right? You might have to redo things. So from a client perspective, from a cost perspective, I think it behooves you to have some discussion about that at the outset before you commit all the resources that are involved in using a discovery vendor and doing it your own way, right? And rolling the dice on that. So I think you need to be thinking about, like, is that really the smartest thing, the smartest way forward? Or do I want to try and get buy-in from them so that then they can't come back and say later, oh, you didn't do this the right way. And then you can say, no, we talked about this. We went over it. I told you we were about to spend, thousands of dollars to run this discovery process. We relied on your agreement, and that's where we are. You're going to be in a much better position with the court to say, they bought it, and that they don't get to return it. And so I do think it's important. I think the amount of meet and confer should be really dependent on how much you're going to spend, because you want to protect that investment because it's expensive. This stuff is really expensive. So there's no one answer. I get nervous about, is there going to be some court order that says, yes, they have to disclose all their prompts in response to a motion to compel or something. And then the question becomes taken out of context. But there will never be an order that says you do or you don't have to disclose your prompts, and that should be the rule in every case. It's just not. Everything is nuanced. Maybe you have to disclose your prompts because you've been engaged in such nonsense all throughout the discovery process and hiding the ball. And it's almost like a little bit of a form of a sanctions that we have to employ to level the playing field and make sure everyone's got what they need. Well, that doesn't mean in the run of cases, people have to disclose their prompts, right? You can distinguish that case really easily. So I don't think there's any one answer, but I do know it's going to be a big issue. And who you have in that meet and confer is going to make a big difference. Do they know what they're talking about? Can they know where to give and where to stand firm? And to me, the sliding scale is the more you're going to spend on discovery, the more you need to make sure you make that investment wise from the outset.
You mentioned another number of things in that response that are upcoming challenges. And you said that a number of your peers haven't seen them yet. You haven't seen some of them yet, but they're coming down the pipe as Gen AI gets more and more adoption. One of the things that's emphasized in the guidelines is the need for judges to stay abreast of what's going on with emerging technology. You also described yourself as unique, sort of an outlier. You've done demos, you've done a lot of research on what's going on with Gen AI. For the rest of the bench, what do you think are the right steps and resources to use to stay current on what's a really rapidly evolving area of technology and a rapidly evolving ability for us to use it in a legal context?
Yeah, but so we're as judges, one of the best parts of our jobs is we really are kind of like lifelong learners. And one of the things that I just had personally in my own world, the whole reason why I even knew what ChatGPT was, is I teach a high school class on trial and the art of advocacy, and I coach a mock trial team, a high school mock trial team. And I, probably 3 years ago, I signed an essay, and I got the essay back, and I will use anonymity here to protect those involved. But my child's in the class with this student, and I said, Tom really turned in a really good essay. It was a little bit of a surprise, but it was good. My child said, "Oh, that's ChatGPT," and I said, "Chat what?" And my husband is a high school teacher, and so he sat down and showed me, and I was just gobsmacked. Like, I have to understand this as a teacher, so having that sense of being like a lifelong learner and opening yourself up to like understanding what's happening in the worlds that you don't live in all the time is really important. From the federal judiciary perspective, as far as what judges are doing or how we're educating each other, really, because it's a lot of our, in the federal system, we have the Federal Judicial Center runs a lot of educational programs, but they're run through, it's a lot of peer teaching. It's judges teaching judges. So we go to, like, our judges go to judge school. We call it baby judge school just to be cute, but I teach at judge school, and I teach eDiscovery, and now that includes a discussion of artificial intelligence. But we also have court webs where the FJC, I've done a court web where I do demos for the judges. We've spoken at the Ninth Circuit Judicial Conference. And then our magistrate judges have workshops. We're really on the front line of discovery in federal courts. 2 workshops a year. That's basically continuing education. So even though we don't have to meet the bar requirements you all do, which I've heard from some lawyers that maybe they feel a little, they resent that maybe slightly, but we still do continuing education as judges. And so on the federal side, I've done seminars on Gen AI at the magistrate judge workshops last year. I'll be doing the same thing again this year. So we are really working to at least have some familiarity in the judiciary. But that doesn't always, you can never have that deep dive that you often need through the use of like expert testimony, especially with emerging technologies, both on the discovery side and on the evidence side. But I know I listened to, once I had that, once I learned about what ChatGPT was, and I had my initial, like, I remember I talked to a friend who's an English teacher in high school, and I said, but how are people ever going to learn how to write? And you hear that from a lot of judges, like, no one's going to know how to write anymore. And he looked at me and he said, we are like math teachers in the 70s when they came out with the scientific calculator, and they swore that no one would know math anymore because this calculator did all the math you needed, right? We're just going to learn in a different way, right? And I think that you have to kind of approach it that way, and our clerks are going to keep us educated as well.
That is such a great analogy to
Wasn't it a good analogy?
It really is. And I'm letting that sit with me for a moment because, as a final question for you, Judge, when we think about that calculator analogy, and I think about my kids who use these fancy calculators that have screens that look like iPhones, et cetera, what is the optimistic outlook, the way you see it? And let's play off of this analogy some more about how we're all going to learn different in 2025 and even beyond. But where do you see us going with Gen AI? There's so many different facets that we covered between, drafting in order to show cause, to drafting some briefs, to doing research, to, in an eDiscovery tool. What's your prediction? Where are we going with this?
So in the federal judiciary where I work, I don't see it changing the chambers relationship really a lot. I think we'll still have our clerks. I don't think it's going to replace any of the clerks. I do think it's going to streamline our work and make it more efficient. I can already see that in my own experience. I think that I would love, if I could have a wish list kind of, you'd start to see scalability for some of these tools, particularly in eDiscovery and in reviewing documents, so that small and medium-sized law firms had both an incentive and an ability to use these tools to make their own work more efficient. Because I think it's not just efficiency, like I think it's improvement. I think that it can be a huge improvement. Now, a lot of people are uncomfortable with that necessarily, but when you think about, when you go back, I don't know about you, two are younger than me, but when I go back to my Cooley days, when I wasn't looking to see what Seth Rafkin did so I could basically plagiarize his work, I had a stack of banker's boxes in my office, and I would pull one out at a time, and I would spend an hour going through the documents, flagging the ones for review.
We had those also, Judge.
Right? And how many times did you get through your second box when you realized there was this whole set of documents that you kind of passed over, but actually they probably were relevant, right? I mean, how's that better than the machine learning techniques that we have? It just can't be, especially when you combine both, right? What if you have the human backing up and the computer doing a lot of the grunt work? So I hope to see more of that, and I hope it trickles down to the firms that are